Good morning.
Well, good morning, guys. Here we go again. We've never done this before, have we? Here we go again. All right. It is WGL AM, and I am joined by my wonderful co-host. I have Miss Hannah Hill from the National Association for Gun Rights. Good morning, Hannah.
Morning, Bill.
Thank you for being here. And, of course, Mr. Kostas Moros from the Second Amendment Foundation. Good morning, Kostas. How are you?
Good morning. You guys know it was about a year ago today Snopes got denied.
Well, that's a good start to everything there. Kostas. Appreciate that.
Good morning, everyone.
Good morning, everyone. All right. Who pissed in Kostas's Cheerios this morning? Man, oh man.
In court for many years.
let me remind everyone that they are here both from the Second Amendment Foundation and the National Association for Gun Rights, which means there are links in the description box down below for both of you to show their very worthwhile organizations some love. We're going to go through the usual suspects. We got 5 cases. You guys know this drill. You've been following this crap for months with us. Guys, I will let you know that I think we are getting down to the end of our misery one way or the other. There are only 4 conferences left on this term. And unfortunately, they're like in bam, 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 and we're done. I think most of those are on Thursday. I think they're going to Thursday conferences. And if we have a nothing burger today during our other little bit of morning's discussion, we're going to talk about some of the big cases that they got coming up still to issue opinions on. And there's a lot of big stuff, a couple that we're real interested in, but there's some really big stuff out there. So, all right. So Kostas reminded us that it was a year ago that we got snoped. A tough day. At this point, if we were to get snoped, this would be even more painful. This is our conference count so far. So Grant, the rookie in the league here, is already on its 12th conference. So, Hannah, you think we're just gonna keep doing this until the very end of June, and then we're finally gonna get gut punched, or what do you think?
At this point, I wouldn't be a bit surprised. They have absolutely zero sympathy for the fact that we're all breathing into a paper bag right now. So
that's a good point. And Kostas, of course, is going to predict that we're going to get some per curiams today because he's been predicting that.
I'm trying to make it happen.
Yeah, exactly. All right, we don't have the orders list out now. We are right at the bottom of the hour, which means it should be coming out any moment. What we do once the orders list, for those of you who this is your first time, 1, thank you very much. But number 2, we'll do a quick word search. We're going to search for our 5 usual suspects. I don't think there's a lot of other noteworthy Second Amendment cases on conference this week. There's always 922 G1 challenges, but they're a dime a dozen. So, Kostas, one of the things, if we got a nothing burger today, one of the things we're going to talk about is that response brief in Roberts versus ATF from the Department of Justice. The NFA case, they got a little loose with their language in that brief, I think.
You know, it's embarrassing. I think that's one of the cases we're either involved in or backing, but I don't even, or unless it's the GOA one, but I haven't even read the government's brief.
Okay, well,
here we go. We got the orders list. We'll get back to that.
No Duncan, no Lamont.
Oh, well, you checked that fast.
God dang, Hannah Hill. What have you got going on over there? You got like an AI program built over the top of that?
No, it actually landed on my internet, I think, a smidge early this time. No Viramontes. No Gators.
Stupid Grant is always the hardest to search
for. But no Grant.
Suit it out under Higgins.
Oh, yeah, I guess that's a good one.
Yeah.
That way
What's the one there was a per curiam.
Oh, there was? Okay.
Not for us. No,
of course not. No.
Oh, it's
a death penalty case got a per curiam. Okay.
A death penalty case got a per curiam, which means, yes, you are absolutely positively going to be sentenced to death. Okay, well, for the 178th week in a row, everyone, we will be serving a healthy dose of nothing burger. our 5 usual suspects case. Of course, those are the 2 magazine ban cases, Duncan and Gators out of California and Washington. Nothing on those. We got 3 assault weapon ban cases, Viramontes out of Illinois, and then both the NAGR and the Grant case out of Connecticut. And it appears that we have absolutely nothing, which means there are only 4 conferences left. I will let you know when we talk about some of the other stuff this morning before I kick you guys loose. That June 4th conference is already shaping up with some other interesting Second Amendment cases on it. This will now just to I'm the frustration is just boiling over here, but Duncan
I
will,
guess +1 to all of those.
yeah, it's +1
Yeah.
to all of those.
Mhm.
That's exactly right.
You know the
So-
record. So the record for getting a cert grant, I'm not talking about GVRs, but cert grant is 14 for Masterpiece Cake Shop. So now Duncan and Gators will beat that if they're granted. But I think the overall record for relists,
yeah, what is
whether or not you get granted, is 24. So we're heading
Oh,
to
goodness.
it. You know.
Oh, goodness.
Can you imagine going? See, we won't hit 20. Well, wait.
That's all. We're only hitting 24. I think if they hold it over the summer.
Which,
Those SOBs, if they did that. What were you gonna say, Hannah?
I mean, there's a strong possibility that they will at this point. I
Well,
mean, at least that's how I'm feeling about the whole thing, which is
At
not
least
good.
for Duncan, our brief and a couple others, including the parties, I think, said like, please grant it, but if you don't, just hold it until you do some sort of case, you know. So it's possible, but I don't know if that's what they're doing because again, I feel like they would just take it off calendar if that's what they were doing. Just put it where the 18 to 20 cases are, you know.
Right, or those
Yeah.
handful of cannabis cases. We got a
Yeah,
handful of
yeah.
cannabis cases. All of them conference like in January. I think one of them might have been conference like November or early December, and then boom, they just put them on ice. And that
And
kind
it's
of
the constant relists are what have me pessimistic that we're getting another dissent. The problem with that is that should have ended like 3 months ago if that were the case. Like, what is there to write? I keep saying this every week. What is there to write in a dissent? You know, that Thomas hasn't already said. So why are we? You know, why is it taking so long? You know, who knows?
Here's a question for y'all. So we think the current working theory is that the Third Circuit is waiting on the Supreme Court before they issue their ruling on Cheeseman. How soon after Wolford and maybe Hamani come out do you think we'll get a ruling? And if so, do you think that's maybe what the Supreme Court's holding these gun back, the Harper back?
It could go 2 ways. They could have the majority could have an opinion ready, and they're just going to pepper in a few Wolford and Hamani sites so the Supreme Court can't GVR them. Or you could see them ask for supplemental briefing and tell the parties give a supplemental briefing by the end of July. You know, on these 2 cases and whether they affect the case. I hope they do the former and not the latter, because if it's the latter, it's going to delay it by several more months. You know.
Right.
But who knows? It could also be that they're waiting to see the rulings because neither of them are a hardware case, right? There might be some language here and there, color quotes to pull, but they might also just be waiting to see if maybe the Supreme Court opines a bit. But historically, the Roberts Court doesn't really do that. They stick to the very narrow issue. They don't go, you know, and talk about unrelated gun stuff or not just gun stuff, about whatever subject it may be, you know.
It's going to be one situation where I'll actually be really happy to get a Chief Justice Roberts special. You know, like one of those super narrow rulings that does the bare minimum and changes nothing, because that's the only way in which I think we get that quick ruling from the
unless they want to opine. Look, if the Supreme Court wants to put in the majority, I mean, not a concurrence, wants to put in some paragraph talking about and like, hey, and we're noticing all this abuse in lower courts, you better behave. And not that they will behave, but at least that's fine because it would help the Third Circuit in particular, because that would reaffirm to the Third Circuit that, yes, we're doing the right thing here. Let's strike this thing down, you know? So, yeah.
So Hannah, your theory is that the Third Circuit might be waiting for SCOTUS to do something before they issue their ruling in Cheeseman.
Well, it would make sense.
What if it's the other way around? What if the Supreme Court is waiting for the Third Circuit and to see if see if they are placed in this enviable, god dang it, we have to take it because now we got to split.
No, but I think she means
that is what you meant.
You've got 2 things. You've got 2 gun rulings that are about to come down. That's what I think the Third Circuit's waiting on. Then you've got the Supreme Court's action on the 5 hardware ban cases. I think they might be waiting on Cheeseman for that.
Yeah, because remember the Third Circuit did range, And
Right.
then Rahimi came out and they had to redo range en banc again. So I think the Third Circuit's like, yes, we know Wolford and Hamani aren't a hardware case, but we're not going to do this twice. So just in case, we're going to
Just
wait
in
till those
case.
are out and then issue a ruling, you know? Yeah. They don't,
Because
because they know how much this court loves to punt, you know, do it again after Wolford, even though it's unrelated.
yeah, you know how much they like to punt, but they can't really punt on their rulings, right? You see, like for example, we see courts. Well, there's Rob Romano kicks this stat around once in a while, and it talks about some of the cases, some of them out in California, coming out of these circuit courts that we're still waiting for rulings on. Right? There's like this infinite time period for the circuits
Oh,
to get
yeah.
rulings out, whereas SCOTUS, they're going to get all their rulings out by the time the term ends here, pretty much at the end of. Well, now
Oh
we're
yeah,
in June,
I
right?
one of those cases, by the way, is our handgun roster case, which is just a preliminary injunction appeal, and August will be 3 years since oral
3 years.
argument. That's
It-
insane.
in an
So-
interlocutory fashion. You haven't
Yeah.
even got remotely.
Yeah, and we don't
close
even
to
think we're
getting
going to
on
win the
merits.
panel. Like we're just like, just give us our loss so we can go get our final judgment and get on with the case. You know, I'd be happy to be wrong, but I think it's a 2-1 panel against us. But yeah, it's been almost 3 years, so I don't know what the hell the holdup is. You know, even for a while it was stayed pending Duncan, but we completed the supplemental briefing on Duncan last May of 2025. So it's been over a year since that. You know, and still nothing.
Well, refresh my memory. Do we have a full en banc Ninth Circuit ruling on Miller? We don't, do we? Miller v. Monta?
No, that one's a panel, and it's going to be controlled by Duncan, and I don't think it's going to go our way. But that'll just join the pile.
Really? I mean, but yeah, obviously that. But that
Yeah.
one,
So
I got GVR'd what, summer of 22?
was that? I don't think that was one of the GVRs. No, it wasn't. It didn't
Okay.
make it
It
up
was
to.
Duncan
I
was
might
the
be wrong
GVR
about
came
that.
down. Duncan was the GVR that came down after
Yeah.
Bruin.
Yeah.
Miller didn't come down with it.
I don't think. I might have to go back and
don't
check.
believe
It's been a
so.
while. Maybe I'm getting rusty.
I don't believe so.
I think it was.
It was. They take so long. That's why.
It was Duncan. It was Snope, then called Bianchi.
Mhm.
It was a New Jersey case. I feel like the New Jersey Magazine case.
Okay.
And then I forget the fourth one. There was one other case. It might have been Miller. Maybe my memory's just rusty.
No, I believe the fourth one was Young versus Wyatt. Right?
Oh, the
You
other
might
one,
be right.
the other one
You
out of
might be right.
out of
Yeah.
Hawaii.
Right.
Yeah. The open carry one or whatever it was.
Okay.
You know.
Okay. All right. Well, listen, guys, this is getting so old and frustrating that we're no longer going to do a morning scramble. Instead, we got the morning cocktail now. It's getting ridiculous. So, a good old Bloody Mary bar once in a while is exactly what we need to get through this stuff. So, first of all, for all of you who are tuning in around the country, thank you very much. We appreciate it. Just to get you up to speed real quick, we got a big fat nothing burger again. So our 5 hardware ban cases will be rescheduled, presumably to Thursday, and we will be back on Monday doing this Groundhog Day all over again. Now, a lot of people may think that there hasn't been a lot going on with the Second Amendment cases the last few conferences and that just kicking down the road. There have been a lot of other cases that we haven't necessarily covered because, well, we kind of knew what was happening. But I just want to let you guys know that in the last 2 conferences, all of these cases here have, in fact, had their petitions denied. And every one of them deals with the same issue. Even the Florida case, you got a couple, McEwen and Martin there out of Florida. It's basically a state equivalent of, Hannah, care to guess what statute it's the equivalent of?
I'm scared too.
No, these are the 1922 G1 cases, right? These are all the felons and firearms, which the court has shown a absolute lack of complete desire to take those cases. But one of the things I was going to talk about as we come up on the next conference on the 4th of June here is that they are also refusing to take challenges that are brought by the United States. So you have these scattering of cases where a circuit court has said, hey, listen, as applied to this person here, this statute's unconstitutional. And the Supreme Court's not taking review on those cases either.
It's a slight change for them.
It is.
Historically, they've given a lot of precedence to what the United States asks for. In fact, that's why we got Brahimi in the first place, because that was on the request of the United States. So it makes you wonder.
Well, it's true that the federal government has a huge advantage on cert, but they definitely don't bat 1,000. They get denied cert sometimes too. Now, what's going on here in particular, I'm not sure. Yeah.
Well, it does raise the question though, why not hold it for GVR after?
Well, that's the
It-
thing.
who
That's the
knows?
Sort
thing.
of. I mean, it's
Go
not a
ahead. Go ahead,
direct
Kostas.
parallel, but yeah.
Kostas, what were you going to say?
Oh no, yeah, I was just gonna say, who knows why they when they do and don't hold stuff for GVR. Sometimes I feel like there's like different clerks deciding this. Like one clerk says, "Yeah, we'll hold this one," and then a similar case, another clerk who's deciding it goes, "Nah, deny it." Because the clerks have a ton of influence. Other than the high-profile cases, which everyone knows about, the clerks have a ton of influence over what gets granted or denied cert, because they'll like make recommendations when they read briefs. Like they'll read the briefs and recommend, hey, we should grant this one, or hey, we should consider this one, or say nothing and then it gets denied. So a lot of the lower profile stuff the court justices never even see, because they don't have time. You see that list of denials every week. Do you think Justice Amy Coney Barrett or something is sitting there reading every single petition that comes through? Absolutely not. The clerks do notes for them about what each one's about. I mean,
Right.
Justice Jackson's never read a brief in her life, so
She hasn't
I'm
written
sorry, that
many
was a
good
cheap
ones
shot.
either. She hasn't written any good ones either, by the way. But
So yeah,
okay,
you're really writing for the clerks when we do our amicus briefs and stuff, other than in the very high profile cases where stuff gets read.
Did y'all
I
notice the
just
case?
really figured that there was an opportunity to really develop 922 G1 case law had they held on to a whole bunch of these and then GVR'd them after Hamani. Because, in Hamani, we are at least in 922G,
Mhm.
and there is undoubtedly going to be discussion in that opinion about a connection between the activity and them being danger to themselves or others.
Yeah.
So there could be a lot of language that could be extrapolated out of that
Yeah.
to what types of offenses are we trying to requalify a person from. One of the cases we'll talk about in a moment has to do with, neglecting to pay child support, which I'm not condoning that activity, but does that necessarily make a person dangerous? No, it makes them a deadbeat, probably, but under certain circumstances. So it would have been, and then think about if you had 20, 25 of these things sitting around that had all just been on hold now for a few months. And the minute Hamani comes out, all those are just avalanching back down onto those courts. And now you're going to have all of those circuit courts start hatching it out with that new guidance. That would be like the most instant percolation of an issue you'd ever see. You'd have every circuit banging out 2 or 3 of these things. And of course, some of them are going to come back. The losers are going to come back. And then we'd see where it would sit. So it seemed like it was an opportunity to really make the circuit courts do a bunch of work that.
Yeah, 922 G1's in a very strange place right now because the Supreme Court keeps denying cases in part because the government keeps arguing that we're going to do this big rights restoration thing,
Which
and
they have done what so
Yeah.
far with?
Yeah, it's been, we've had the comments in now for almost a year, and that's apparently, so I was reading this article about that. That's apparently not abnormal for a new rule, especially one that gets a lot of comments, because they have to address the comments, and that takes a while. But I mean, it's weird for them to be arguing, hey, don't take cert on these cases. Sorry?
It didn't take that long to address the comments on the pistol brace rule and some of the other rules.
Well, that's, yeah.
The Biden administration, so that you can step on the gas.
You would hope they would just ram it through. But yeah, it's also, this is going to be one of the more harder ones to implement. I'll grant them that, because by their count, they're saying 1 million people a year will use it. Well, that's a pretty big bit of bureaucracy there to, set up. I know they're trying to have it relatively automated and just, grant the easier ones and then maybe manually decide the harder ones. But yeah, it's just strange for the government to keep telling the Supreme Court, you don't need to worry about this issue because we're coming up with this process. Well, where's the process? I think Todd Blanche, he wasn't deputy, or he was a deputy AG at the time, but at SHOT Show at an interview, he said that they expected it in March to be done. Well, it's June now. So, I know we're very demanding and we want stuff done now, but this is important, so.
I mean, we're not that demanding. We'd also like updates.
Yeah, I feel like I'm the least demanding person to deal. I get crap for how nice I am to the government on this stuff right now. So,
well, yeah, that's a wonderful thing.
I mean, I think
Sorry.
the thing is, what's annoying is that we keep seeing the DOJ restore rights to a select handful of people bypassing the process. And you're like, all right, so how's that process work? And how do you get lucky enough to bypass the rule process that's not even released yet? Meanwhile, the window of time for the DOJ, for people to use this one.
That's the thing right there, Hannah. That's
shrinking every day.
That's right, because we do not know when the political winds shift, which direction they will shift in. We do not know. This thing was defunded for decades is refunded right now, could be defunded again rather rapidly. And it's a narrow window of opportunity for a bunch of people who otherwise cannot get restored to get themselves restored. And that's going to be very, very important to some people. Very important.
I think
Go ahead, Kostas.
Oh, sorry, I keep interrupting. I'm such an ass.
No, that's fine, dude.
I think actually I'm pessimistic about a lot of things with President Newsom in 2029. Obviously, like a lot of those
living through that. All right, so don't say that. Come on.
So all these DOJ cases that we're excited about, those will all get dropped, etc. One thing I think would survive though is a rights restoration program. They might tweak it to narrow who can apply, but I don't think they want to deal with this flood of 922 G1 lawsuits again, whether it's a Democrat or a Republican in the White House. So I think they would allow some sort of system to survive it. But yeah, they might create more rules and say this person's ineligible, and narrow it down. But I think overall, this is one of the things I think will survive long term. We'll see.
Yeah, but under a President Newsom, which again, I almost need a barf bag to say that, but number one, that presumes that he would actually want to restore rights of people, which I believe your state's like the worst state in the nation.
Oh, no. He wouldn't want to. It's more about that they know that if they don't do it, if they go back to the old way, then they're going to have a bunch of new lawsuits to deal with. And probably finally a Supreme Court ruling on this topic, because the Supreme Court punted because the government told them that, hey, we're working on the rights.
That's one of our theories, is that they have punted on so many of those cases because DOJ promised the solution, which ain't here yet.
Right.
Well, my view is a little bit more pessimistic than that.
Okay, that's right. I'd be more realistic too.
Well, the thing is, it may well be, and to their credit, they may well be taking their extra time with this one to avoid any APA challenges that would to the rule that would arise under President Newton. But I don't think you'd have to bring a lawsuit to strike the rule down. If you remember what was in that original rule that they rolled out, it's very, very discretionary. It's very, very broad. There's really no guarantee that anybody's going to get their rights restored under that. So they've got all the tools they need to keep the process itself in place once the political will is there to deny everybody. I don't really see what grounds there will be to sue over a denial from the Department of Justice under that rule or under the enabling statute.
Well, you could still sue. Like if you get denied, then at that point you could still sue because you've exhausted your administrative remedies. Right. And you will have new Brian David ranges all the time who are super sympathetic and could challenge it if they were denied. So I do think that's why I'm usually pessimistic, especially about the prospect of what a President Newsom might do. But I think at least the low-hanging fruit cases, the ones with great facts, will get rights restored just to avoid the litigation.
Do you think the Supreme Court's appetite for restoring rights, taking the who cases versus the what and the where cases for gun rights, you think that's going to increase though?
I mean, they have been taking the who cases. That's what we've got. Rahimi, we've got Hamani. So that's like that's about to be half of the Supreme Court's Second Amendment jurisprudence is these who cases, right?
That's brilliant, for sure.
Yeah. So yeah, I think they would, and the 922 G1s again. I think they might have taken something like range given the Third Circuit ruling, and there's a circuit split on it. And the only reason they didn't, again, was because the government promised them that this program was going to happen. So yeah, because otherwise they'd be. Maybe I'm wrong, and they would have denied it anyways, even without those promises. But there's a circuit split on this, So it is an issue you would think they would otherwise take. Yeah.
We are all very fascinated. I know there are some attorneys that would love to get rolling on 925 restorations right away. Obviously, it could be a good financial model for them, but they can't even figure out what the process is until they know what their process is as lawyers, until they know what the process is according to the Department of Justice. So if anyone from DOJ is listening, can you guys get on that here pretty quick? We're down to a couple of years maybe. So, okay, guys, there's a conference coming up. I guess it's going to be Thursday. It's June 4th. And we got some interesting cases on that conference. Presumably all 5 of our hardware ban cases are also going to roll over to that too. So add those to it. NSSF v. James is back on, which, as you guys will recall, is all about the PLCAA's predicate exception and what these states are doing in a lot of ways to pass these Consumer Protection Act, false advertising, unfair trade practice, and stuff like that. These statutory workarounds to the PLCAA. New York tried to waive its reply. Supreme Court said, nope, don't think so. Made them reply. They finally got the reply brief in. There's about 8 or 9 amicus briefs on there. The Supreme Court has already dealt with the PLCAA in the last couple of terms in Smith & Wesson v. Mexico. Interesting case. If you guys, either of you guys had a chance to take a look at that, and I know, Hannah, you guys have been concerned over at NAGR a little bit. We've had some private conversations about some of these reach arounds, if you would, of the PLCAA.
Well, this is an easy GVR in light of Smith & Wesson versus Mexico, it would seem. I mean, if the Supreme Court this is just, I would think.
Yeah, I'm not so certain about it. I think this is a bigger issue, and I'm worried that if this gets what happens is if this petition gets rejected, because this is really dealing more with the issue of state-created special causes of action that are not necessarily defined under common law, tort law, and all this crap. And what I'm worried about is that if the petition is denied, we're going to see just this massive doubling down by a lot of states to do that, right? I actually did a video over the weekend. Let me explain one of the things that you can do in Virginia right now. And Kostas, did you see that we got Cam Edwards lined up for our Behind Enemy Lines next week?
Yeah. I'm excited.
So
always love Cam.
Yeah, he's a great guy, great journalist. But out in Virginia, you've had a lot of these Commonwealth attorneys and sheriffs just go, no, not going to enforce it. Not going to enforce it, right? Well, let me tell you another county that in Washington State that decided, no, not going to enforce it. It was Cowlitz County. You know who had a gun store in Cowlitz County? A guy named Wally Wentz. The store is called Gators Customs Guns. Okay. Wally was selling magazines out of he was blowing them out. And the local sheriff in Cowlitz County knew he was doing it, and he didn't care because he believed the law was unconstitutional also. So Wally was never prosecuted criminally for selling a single magazine. The way this case exists is that Washington State passed these parallel consumer protection laws, and when the Attorney General found out he'd been selling the magazines, they sent an investigator in, they bought a couple of magazines, and then they used that to turn around and civilly sue him. And when Wally decided he wasn't going to pay the settlement, instead he was going to fight it, they got all of his sales records. And so Wally owes $7,500 per magazine that he sold. So if Wally Wentz loses this suit and the state of Washington tries to collect on it, that's the end of Gators Customs Guns.
Yeah, and that's why the Supreme Court, and yet another reason the Supreme Court needs to not be a bunch of cowards and grant cert or at least GVR Gators guns, because it's another example. You know, if they deny cert in Duncan, a bunch of people become felons overnight. Granted, I know Cal DOJ will probably say, okay, you have 90 days to dispossess. They'll give us some timeline. I get that, but a lot of people will stand on principle and refuse, you know, and they'll be turned into felons for refuse. And now this is another example of the destructiveness that comes from inaction. So I hope part of the reason these cases are getting relisted is that the court is conscious of this stuff and, you know, is trying to figure something out to help people, because if not, if they just deny everything, then people like Wally will be punished because they did the right thing. In essence, they stood on they stood on principle and refused to comply with an unconstitutional law. So it's basically thuggery. I mean, I would hope that, you know, there's something that I doubt there's much the law enforcement can do to stop a collection, but I guess that's all I can hope for. And that's another big problem, you know, out in Virginia, you're talking about these sheriffs or whatever they are, DAs. I'm not sure which it was, but who are saying, right. And they're going to refuse to enforce the law, but that's great. But what does that mean? So if you acquire a magazine, you won't be prosecuted there, I guess, or whatever it is. But what does that mean for gun stores? Most of them are still going to refuse to sell this stuff just because understandably, they don't want to be bankrupted by the state, you know?
Well, see, so here's the thing. They can't get bankrupted by the state because Virginia didn't pass parallel legislation like. But here's
but they will. But they will if
absolutely they will. But here's the thing: if you're an FFL in Virginia and you get busted on it, it's only like a level 1 misdemeanor or whatever they call it out there in Virginia. But you also lose your right to possess a firearm for 3 years, which if you're an FFL, that could have a mildly devastating effect on your business.
Right.
So, but it's because, like, for example, you guys remember the big brouhaha just in the last couple of weeks about New Jersey subpoenaing the gun stores, wanting to know how many Glocks had been sold, just randomly asking for all this
Yeah.
data. Okay,
Right.
these are all being done pursuant to those laws that were written to work around the PLCAA. Because when you read these laws, and I've geeked out on all of them, they give the attorney general this broad discretion to demand all sorts of information to ensure, the consumer is protected, the community is safe, and blah, 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 blah. And so they are literally, there is a large wholesaler in the United States. I'm not going to name their name, but a very large wholesaler that produces a lot of component parts for retail operations. So if you're looking for pistol grips, hand guards, triggers, all sorts of component parts, predominantly for semi-automatic rifles, but other things, they have refused to ship to Washington, Oregon, and there's, I think, New York, New Jersey, and a few other states. Not because it's unlawful to do it, but because they are getting so many discovery demands from the attorney generals in that state that literally cutting off and not shipping will be cost efficient compared to shipping and then having to deal with all these discovery demands. And one of the gun stores here in Washington, who will remain nameless also, but a very successful gun store, is ordering about $4 million worth of parts alone from the gun store, this one gun store, a year. So that you can imagine how much money they are leaving on the table. How much money is it costing them to go through all these discovery demands on a daily basis, I'm hearing.
Yeah,
So it's
this
kind of
is
like this mafia shakedown that's going on.
It is, and it is a brilliant strategy on their part. I mean, you choke off the supply of guns, people can't exercise exercise their right unless you can get it somewhere else and bring it into the state, or unless you can make your own. And on the other hand, you've got all the ghost gun laws, where they're trying to crack down or prevent you from building your own stuff. And that way you've pretty surely taken the right out of people's hands without ever actually passing an outright ban. And that's why it's so essential that the Supreme Court step in. There's a difference between the right to possess and the right to sell. But at the same time, if you allow a broad-based ban choking off the supply, then at that point it becomes the right is the same. Um, so yeah, a lot at stake if they don't do something about that one.
It's like they learned their lesson from the failed war on drugs, because you bring up, like, we can either attack the supply or the demand. The war on drugs was like, we're gonna, the just say no part was, trying to attack the demand, but actually at the end of the day, it was all about the supply, wasn't it? So interesting. Okay, so here's another couple cases that are coming up on that June 4th conference. This is a successful challenge to 922 G1, but you'll see who's listed first as the petitioner. So this is a case where the United States actually lost in the Fifth Circuit as applied. Cokerham is a person who had failed to pay child support. And the Fifth Circuit had said, no, we see as applied to him that he should not be disarmed at this time. So this would be, I think, the third or fourth case with an as-applied challenge where the United States lost, that if it's denied next week, the United States continues to lose those cases, which I think is kind of interesting, because it appears that after rejecting all of these cases from the high court, they are really, doesn't matter what side they're coming from, they appear to be letting these things percolate out quite a bit in the lower courts, which again, I'm wondering why they just didn't do a little bit more waiting on. You didn't have to take all of the 922 G1 cases. You could have taken like a dozen of them. Cherry pick a couple. We got a real violent person. We got a drug person. We got a non-violent person. You cherry pick a few of them and GVR them back. And I don't know why they didn't do it.
It may be that the Supreme Court's main concern with 922, I can't talk this morning, with that law is about whether or not we're going to start arming dangerous people in their view. And that was, of course, why they stepped in Rahimi, which, by the way, came from the Fifth Circuit as well. So the Fifth Circuit is the one that keeps getting smacked down the most for accurately applying one. But be that as it may be, if they say no to this one, that leaves the Fifth Circuit precedent in place saying that clearly non-dangerous people actually can't be disarmed. And that would be a huge thing for those 3 states. And if the Supreme Court doesn't actually care about that, then that's one where it would actually work in our favor.
That's right. Do we, Kostas, do we got opinions coming out this week, and are they coming out on Thursday?
Yeah, it's going to be Thursday, I believe. By the way, one thing we forgot to talk about when we got the orders list was that Gardner, who was denied, unfortunately, as
Oh,
expected.
I
Yeah.
totally had forgot to track
Yeah,
that.
I did too. It just occurred to me. I'm
shot.
like, oh, that was this week. Rehearings denied. Yeah, her rehearings denied, which isn't surprising. They almost never grant rehearings. So yeah.
It is incredibly rare.
Yeah.
So
it is still a bummer.
That
Yeah.
part pro se again. So what started
Yeah.
as a pro se ended as pro se too.
Yeah,
she did an
and I
excellent job
understand
with
why
her-
Pete did that because he knew
Oh, yeah.
it was hopeless, you know. So
Oh no,
yeah.
and when I had talked about it, and when I had mentioned that the attorneys had withdrawn, I had explained on the video that this is a very normal practice, that the attorneys had absolutely not left her hanging at all.
Yeah.
That is very customary. It's a very sad end. I'm still trying to talk to Miss Gardner and see if we can get her to come on to the channel and talk
It's
about her.
an injustice. It's a complete injustice, and it was cruel how they went about it, requesting response and then doing
Yeah.
nothing. You know, like even after again, U.S. senators, various states, like our Second Amendment org, she got so much high-profile support, and they didn't say anything. So it's a bummer. Yeah.
Speaking of bummers, when you guys have an opportunity to read the United States Department of Justice's reply, or it's actually their cross motion for summary judgment, Roberts versus ATF. This is yet one of the many, many challenges to the NFA, American Suppressor Association's in on it with Second Amendment Foundation and things like that. This comes out of their civil division, the DOJ's reply, not the civil rights division, the civil division. Okay. And I'm going to tell you guys that the DOJ got really, really sloppy with their language again. This is a brief that, in defense of the NFA, and it's the usual suspect of arguments. You know, it's the Commerce Clause, it's the taxing power, it's dangerous and unusual. So we get to do this. Okay, there's nothing that unique about the arguments. But the depths in which they go through discussing and justifying their positions, they get really, really loose. And in the section on the Second Amendment, you will see that they play the same little, hat trick game that every town in Brady does, where in one paragraph they start talking about dangerous and unusual, and by the next paragraph it's uniquely dangerous. Okay.
What standard is?
Sorry.
So yeah. So
Not what standard is at all.
I got a video recorded over the weekend, and we'll get it out. But it is again, I don't think any of us should be shocked that the DOJ is defending the NFA. I think that they've been very consistent about that. That is also not being handled by the Civil Rights Division. It's not being handled by the Second Amendment section. So I think that's also very, very important to point out, is that typically, if you're going to have Miss Dillon's fingerprints on it in her Second Amendment division, this is going to be when the DOJ is actively suing somebody. It is the plaintiff's aspect of what they're doing over at DOJ. Whenever we're seeing DOJ defending laws like 922 G1, even under whatever circumstance it might be, that is not what the Civil Rights Division is dealing with. But
What
you
you
got
really
sloppy.
Cool. Sorry.
Okay,
Go ahead.
you were going to say, Hannah?
What you really hate to see is them arguing one thing on one hand and the opposite on the other, because we know that cases coming out of the Civil Rights Division, which will have Barry Arrington's fingers on them, are not going to mess up dangerous and unusual and flip it with unusually dangerous. He
Yeah,
knows the standard.
I'm sure Barry will get that very clear. I've
Right.
read his briefs before you have as well. So
I mean, I guess it doesn't hurt you for the same party to argue completely opposite lines of argument in various cases in the courts. But that's certainly something that we would not do in our cases.
Well, we can point it out too, if they argue one thing somewhere and another somewhere else, but yeah, we'll see how much
what
the
I
other
worry
judges
about with
care.
this Roberts brief is that there is a lot of broad language which could be argued for broad application of a lot of things, that when you put them in the hands of states like California, and Illinois, and New York, who are now writing briefs to support new civilian disarmament legislation. This is the stuff we're going to see in 3 or 4 years. Like, even the United States Department of Justice at one point acknowledged that blah, 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 blah. And, are those what dispositive of those arguments? No, but they are helpful. Okay, real quick. This is going to be an interesting stretch down. June's going to be real interesting. Big cases remaining. And let me explain to you what I'm talking about. I went by and took a look yesterday at how many cases are we awaiting rulings on from the United States Supreme Court. Obviously, there are 2 that we are very carefully watching, that being Wolford and also being Hamani. And we actually expect, I think you can disagree with me if you want, but we expect to actually prevail on both of those cases. You guys agree with that?
I would agree with that, yeah.
I think that's more likely than not. Yeah.
Okay. But there's some big stuff coming out, not related to the stuff we talk about, but very important to the country. There is Trump v. Barbera. That's the birthright citizenship case. That has yet to still come out, okay? There is a case called Trump v. Slaughter. Didn't get a lot of publicity, but this talks about the presidential power to terminate people without cause that are running, these large agencies and things. Had to do with the Federal Trade Commission. Very,
Great name for that one.
Huh?
Great name for that one.
It is, because unfortunately, Miss Slaughter did get slaughtered at the hands of President Trump. Okay, this is now Calais versus Louisiana. The whole racial gerrymandering already kind of has some earth-shattering application. Okay, Watson versus RNC, case that actually comes out of Mississippi. This is going to determine how far after the election can you continue to count ballots.
Oh,
I can see Kostas' head pop up, because his state and my state are notorious about taking a long time to count ballots.
Yeah, like 30 days after California's still counting. And it's because they allow, they count ballots as long as they were postmarked by election day. And sometimes I feel like they even turn a blind eye to stuff mailed after election
You think
day.
they might, right?
So yeah, that's something that needs to be figured out. I've long maintained, if you want to do vote by mail, fine, but the deadline to mail it should be a week before election day. So, and if you can't do that, then there's literally ballot drop boxes at polling places that you could use on election day. You don't mail it if it's too late.
Well,
but anyway.
what's even weird is that when you get so ingrained with mail-in balloting, like we do in Washington State, because we haven't had polling places here for years. We have a current mayor in Seattle who is complete and total dimwit. I mean, just embarrassing dimwit. Socialist mayor. And she ran against the incumbent, who was also a dimwit, but less of a dimwit. And at the end of election night, he had a 2 percentage point lead or something like that. And everybody was like, the mail-in ballots are going to come in. They're all going to be for her, and she's going to win. And they were literally calling it election night. And guess what happened? The mail-in ballots came in. They were all for her, and she won by a slim margin.
Yeah, that's the problem with this math. It's in California too. It creates at least the appearance of impropriety, and maybe there's actual impropriety. I don't know, but it at least looks bad, and they're supposed to avoid that. When there's an election in California and it's like the Republican is slightly ahead, or it's a dead heat going into election night. And by the end of the night, it's still tied, or the Republicans slightly ahead. Pretty much guaranteed that they're going to lose that seat. It's going to go to the Democrat as more and more of these mail-in ballots get counted. It's every time, and it's only in one direction. So yeah, I mean,
only in one direction, and I have a hard time believing that predominantly those ballots are only being used by one party.
And Florida fixed this, over a decade ago. Now Florida gets counted up in a day, so there's no excuse for California to continue to take a month to count ballots.
Florida has their it's amazing how fast they get their results in. Let me show you a couple other big cases, ones that we won't talk about here, but there is Little v. Hecox and West Virginia versus BPJ. These are state laws which ban trans athletes from participating in high school athletics with the wrong gender.
That one had a funny development last week.
Which was it Hecox?
BPJ. So part of the argument,
one of them has been trying to moot their case ever since they got to the Supreme Court and hasn't been able to moot it.
Yeah, one of them was that they had argued in court, well, BPJ is not winning, stuff like, and then last week they did a 28J or whatever it's called at the Supreme Court and told him actually there was a bunch of races or whatever sport it was last week and he won all of them, or she won all of them. I'm not trying to misgender anyone, sorry, but BPJ won all of them is the point. Beat all the biological females, just crushed them. And that was hilarious to me because there's this giant Supreme Court case skate and this kid was like, nah, fuck it, I'm gonna win. Like I'm not gonna. He could have thrown it. You could just take the dive so you win your case, or at least improve your odds. But nope, crush those girls.
Oh man, take the dive. That's a good one. All right, here's the other case. This one hasn't gotten a lot of attention, but I'm gonna actually geek out on this case this week. Chatri versus United States. Chatri, I'm not sure how you pronounce it. This has to do with the application of the Fourth Amendment to geofence warrants. You guys know what geofence warrants are?
It sounds something futuristic.
Right,
and scary.
Here's how it works. Let's say that you had a shooting occur Saturday night at the corner of 4th and Main Street, okay? And the shooter is still unidentified. You could subpoena the cell phone companies and I want the identity of everybody who was pinging off a tower in this one little area right here. And you can kind of then use that data to extrapolate back and start figuring out the identity of people who were in that geographic location at that particular time. And then, of course, from there, you can whittle on down and bada boom, bada bing, you might be able to develop a suspect.
I'm surprised that's not already... I mean, they're surely already doing that, I thought.
So it's an interesting thing here because when we get into Fourth Amendment issues, Hannah, typically in the criminal law, the way we always try to explain it is it's just really about what's your expectation of privacy. Right? I mean, that's the easiest way of doing it. Now, what is your expectation of privacy when you are out in public? Because presumably all these things would be in public. There's potentially hundreds of eyewitnesses that could have seen you there. So you don't have an expectation of privacy in that. But we're not talking necessarily about that. We're talking about data that is actually on your phone related to where you are located and what's your expectation of privacy in the data that you have on your, right? You see what I'm saying? And it may be heightened. It's going to be an interesting issue. I'm guessing that this court is going to be okay with it, but I am very interested to see that. And I think for criminal attorneys, anytime we're dealing with Fourth Amendment application issues, those can be really big things. So it's an interesting thing.
Fascinating.
Yeah. All right, guys, guess what? We're back next week. We're going to be back here doing this again. To all of you who tuned in today, we really, really appreciate it. We're sorry for the nothing burger. We're really sorry for like 4 months straight of nothing burgers. But hey, we don't write the orders list. We just read it, right?
This is a great, fun show because you never know when the season finale will be. Or maybe we might end on a cliffhanger.
That's true.
Could just end very sadly.
It's either going to be a cliffhanger or we're all just going to drive off a cliff like Thelma and Louise at the end,
Yeah, it could just be like we end triumphantly, or like next week is just the red wedding and we just get
just a picture of the Hindenburg and then a red line.
It should, what happens if it denies cert? It shouldn't even cut to our reaction. We should do the Ted Turner thing where like CNN apparently had a program set to play if the world was ever ending, like if there was nuclear war, where it would just be this random band playing at the White House at the end of the world. I don't know if you've seen that video.
No,
I will send it to you guys.
Just get it just in case.
So they had it ready to air in case there was ever nuclear war as just an end of the world thing. And we should just play that if all the cases are denied.
That would be hilarious.
You want to know the sad thing is so I try to make our programs both intellectually stimulating, which you two are the reason that happens, and then I try to make it visually stimulating, by building graphics for this thing and stuff. And I actually have graphics built for a good day and a bad day, and they've been sitting on the board here for like months now.
The thing about these kinds of things, you have to prepare both sides, but only one side is going to be shown, and that means that sometimes your best work you never get to publish.
Yeah, exactly. Well, listen, real quick before I let you guys go, let's find out real quick first from Hannah and NAGR. What's on tap for NAGR this week?
We've got a few cases to evaluate, some in terms of strategy and some in terms of amicus briefs, but requested. One interesting one out of Texas, which deals with the standard for self-defense. It comes out of a criminal case.
Oh,
So
I'm excited to talk to you about that one.
yes, there's a lot of interesting stuff to sink our teeth
Cool.
into it, that one. That and continuing to basically beat the bushes and try to raise support for a pardon for Kate Ademiak.
Yes. Yes. And for any of you who's still tuning in, thank you very much. Listen, again, call your local congressperson, tell them to pardon Patrick Tate Adamiak. It's really the only way to get this kid any level of justice that he deserves.
Right.
We've exhausted every other thing. I know that both of your organizations have been very diligently working behind the scenes about this. I'm confident that all the Second Amendment organizations are diligently working behind the scenes. So I'm hopeful we're going to get some resolution on that. So thanks for bringing that up too, Hannah. Kostas, what's on tap for Second Amendment Foundation?
Well, a couple of things, but the main one I'm watching this week, and we'll do a thread on the SAF main page, is the Baird oral arguments in the Ninth Circuit, which you guys also did an amicus on. Terrible panel draw, so we're going to lose. But hopefully those great amicus briefs we wrote get cited in a dissent, I guess. I don't know. By my count, I hope I'm wrong. Look, I hope I'm wrong. And some people were making the mistake again where they were saying, oh, look, there's how many Republicans on this panel. But if you know the actual Second Amendment history of some of these judges, by my count, it's an 8-3 panel. And there's no Van Dyke on it. But there's Judge Lee, who's great. So we'll see what happens.
Carry ban?
Sorry? Yeah, that's the open carry case. So that one's we did an amicus, so did you guys over at NAGR. Right. So and Alex's was great. So hopefully somebody brings those up, but we'll see what happens. Now
Should be fun to watch it.
Yeah, and the other thing going on is I'm finishing up my draft, hopefully this week, of my next law review article. And once that's done, I'll post the draft, the working paper online for everyone to read.
What's the premise of it, Kostas?
It's about taxes on guns and why they're unconstitutional. And I think that's timely because I think that's an issue that's going to be heating up now. California, of course, is already under litigation. That ruling's been delayed again until next week. The tentative ruling at the trial court level. And then Colorado has one at 6.5%. And although Virginia and Minnesota didn't pass it this time, I'm sure they will. That's coming back. So that's a new hot issue in the field. Yeah.
Well, I am super excited. Tomorrow, I get to pre-record a new video series, and it's going to be called Text and History with Barry Arrington.
Oh, whoa. He's doing a whole series with you?
That's the plan.
Did you get hired by the government?
I want to thank the folks over at DOJ and the Trump administration as a whole that I think have made that there's a tremendous amount of transparency to come out of this administration. And so, yes, we're going to try to make it a regular thing. We'll predominantly be talking about ongoing litigation that DOJ is involved in from the Second Amendment division. Obviously, I'm sure there will be some rules in place about, hey, I can't be out here talking smack about Janine Pirro. and if you know Barry on a personal side, Barry doesn't do a lot of smack talking. It's just not really in his nature at all. So he's not for that. But what I'm really excited about, and hopefully we can pull it off, is I really do want the country to get to know who Barry is philosophically and intellectually, because he's a complicated person in a good way. He's incredibly bright. He's amazingly well read. His attachment to history is remarkable. That's the whole idea of the play. I'm text, he's history, you see. And so I think if the country can get to know him as a person, they're going to feel a lot better, at least about what that part of the Department of Justice is doing for him. So I'm hoping it's going to be a win-win for everybody.
Barry's great. Yeah, and that's a big get for you as well. So I very much look forward to watching that. That's awesome.
It'll be fun. All right. Yeah. Listen, you guys, as always, thanks so much for being here. Thanks for making something out of nothing. For all of you tuning in today, thank you very much. You guys are awesome. I know some of you check in every single week, and you know it's probably going to be a big burger, and yet you still tune in with us. So I want to thank all of you very much. I hope all of you have a great week. Thanks, guys.
Thank you.